May it please the court, my name is Virginia Vetter, and I'm here on behalf of the appellant, Ronald Moore. The major issue in this case, the brief was addressing the issues basically of income, alimony. And the major issue and the first issue in this case is the calculation by the trial court, the inaccurate calculation by the trial court of Mr. Moore's net income. As the court is aware, Mr. Moore is an independent contractor, 1099 independent contractor, working for two insurance companies. One, his major income comes from Excalibur, where he sells benefit programs to large companies such as car dealerships. Secondary, also independent income comes from New England, and there he sells various products including 401k, individual life insurance policies, etc. So as a result, he has several licenses. Now, the basic problem with the court's calculation of the net income is, first of all, it's contradictory.
Let me see if I've got this straight, and maybe we can cut to the chase. In the judgment, as I read it, the trial judge notes that during the relevant periods of the calculations, the highest gross amount that is achieved between these two places of employment is approximately $280,000.
Gross, correct.
And then the judge takes that basically and divides it by 12, and that's the number he works with to come up with the child support and the alimony figure. Is that
correct?
The essence of your appeal?
Correct, without deducting anything. No taxes, no health insurance, no business expenses, nothing.
Well, that's what I wanted to ask you, Ms. Vetter. I have the final judgment as well here. Did the judge deduct any of these?
Nothing.
So nothing at all? Because I have it here, I don't know whether or not I'm missing a page.
No, nothing. And he contradicts himself. On one hand, he says, and that's on page 5 of the judgment, record number 13.
What page? What page?
Page 5 of the judgment.
All right.
He found that his net statutory monthly income is $23,295, and that's the $279,000 for year 2012 divided by 12.
If you multiply that by 12, though, you get the gross number.
Correct. That's the whole problem. And yet, in another section, he finds that his net earnings between 2008 and 2012, and that's record 1382, it's probably page 4 of the judgment. There he found his net earnings have been between $42,000 and $191,000. Yeah, the second figure.
That's in paragraph C, right?
Yes.
And he doesn't explain.
No.
So what's his... How do we make... I mean, obviously, this appears to be an error. So how do we rectify this?
I think it has to be reversed and remanded with instructions that he has to take into consideration these statutory deductions, the health insurance, and the ordinary and necessary business expenses, which he had totally disregarded, without any rebuttal evidence from the other side that any of them were not ordinary.
Just to take the other side for a minute, is the judge entitled to just conclude that because these numbers, and I looked at all of the Schedule Cs and all of the financial affidavits, of which I think there's 5 or maybe 6, and they're kind of all over the board, although the one that seems to be the operative one is the one that's the most conservative.
Yes.
Can the judge just look at all that and say, I can't make heads or tails out of this. I don't have any faith in these numbers or this testimony, so I'm just going to pick this number?
No, the court cannot, because therefore it's using its own opinion based on no evidence whatsoever that says these are not reasonable expenses. There was no expert provided by the wife to say that. For instance, the automobile, and you're right, it was the 2012 upon which he based these, and it was the most conservative. He used 55 cents a mile for automobile, which is legal. It's the way the IRS permits.
There was no testimony, witness or otherwise, to say that the business expenses were unreasonable?
No, none whatsoever. So if there are any other questions on that issue, I think it's obvious that there's an error here. Because of that error, it really skews his ability for both alimony, for child support, and I think it has to be reversed, and I think it has to be recalculated. And the ordinary and necessary business expenses have to be considered as part of it. That's the law. That's what's on the financial affidavit. And then finally, on the one last item with the tax deduction, it is, and the courts have held that it is discretionary with the court. The reason we're saying it was an abuse of discretion in this case is that the court specifically said, because I want her to get X amount of dollars, $6,700 a month, something like that, I'm going to make it not tax deductible to her. But the court also said, I'm not going to go into the dissipation of assets because I penalized him in the equitable distribution for that, and I'm not going to penalize him in the alimony determination. And yet that's exactly what he did. As the court is aware, it is very common, if you want the payee to receive X amount of dollars, you tax impact it. You make the payor pay more so that the payee will have more money to pay the taxes. And that way, it would not have been penalizing Mr. Moore.
I didn't do calculations, but it seems to me that because he's in a relatively high tax bracket, that if you tax affect the alimony rather than make it non-deductible to him and taxable to her, it seems like there would be more money to go around. Is that?
I would think so, because on his financial affidavit, as I pointed out, paying $8,000 a month, a temporary alimony of $8,000 a month, left him with tax liability on a monthly, almost $18,000 a month, of only a little over $3,000. You take away that $8,000 tax deduction, and it's obvious it's going to go, the tax is going to go up considerably.
He's
So
probably 38-40% tax bracket,
Yes.
so that's a lot of,
Yes, it
that's a
is.
sizable benefit to him,
yes, it is.
which could then be used for other things. Actually could probably increase the alimony to her by tax affecting
It is, and it does, that happens very frequently, so it really doesn't even benefit her either. If the court has no further questions, I would reserve for the,
Okay.
why, thank you.
Good morning, may it please the court. I'm Lorena Kiley. I'm here on behalf of the wife. She's also raised a cross appeal, and I would just like to touch on the cross appeal because it won't take very long before moving into the income issue. And admittedly, as to both of these issues, the record could have been fuller. You know, I deal with the record I'm given, but there was enough evidence in the record for both issues on the life insurance to secure the child support and the extraordinary expenses associated with their son Daniel, who has Down syndrome. As to the life insurance, there was some testimony that there is an existing $10,000 policy, and there's also a suggestion that there was some other large policy, a $1.5 million policy. I don't think that got into evidence. I don't know. But given that that they have a child with Down syndrome, the life insurance, it's not for the benefit of the wife, it's for the benefit of Daniel, who's going to need care his entire life. I would ask as to that issue that you remand, at least so the judge can look at whether that $1.5 million policy is in fact in existence, or at a minimum as to the $10,000 policy, as to which there was no dispute that be used to secure the child support.
I guess right now, from our standpoint, we'll review this for abuse of discretion. Would you agree
Absolutely.
with that? So we basically have, in order to remand it, we have to conclude that no reasonable judge, given this type of scenario, would have possibly, done what he did. And so it's pretty much of an uphill battle.
I completely agree, and normally, the abuse of discretion standard is so high, it's difficult to reach that standard. But when we've got a child here with Down syndrome, that both parties stipulated he's going to be dependent, that it's really, I think it was an abuse of discretion for the judge not to order the security of the child support with life insurance given those circumstances, and that some evidence. There wasn't a lot, but there was some evidence that life insurance was in existence. It would be easy to continue it. The other issue was the
child support, and flipping back the child support for the child, my understanding is that child support, typically child support would end when the child turns 18.
Correct.
But in this case, because of the circumstances, as I have reviewed the record, it will be indefinite.
Correct.
Is that correct?
Absolutely. And with, with a child with Down syndrome, there are extra expenses that a regular kid doesn't have. There was, testimony about, in her my client's financial affidavit, there's speech therapy, special tutoring. The expenses don't add up to a lot, and I would suggest, counsel in her brief argued, there wasn't, that wasn't testimony about the exact amounts of these things. They totaled about less than $400. That the better thing that the trial judge could have done as to those is the order that the parties, share them based on their relative child support percentages, because there was evidence in the record that those expenses were being incurred. And granted, the child support's going to continue for a long time, but right now, the wife is the one who's paying for all of these extra expenses which the child needs, and there was really no dispute that the child needed them. On the husband's income, the husband's financial affidavit had the $23,295 as his gross net business expense. Admittedly, I'm not sure exactly where this trial judge came up with the number that is the net number. There was so much evidence that came from the husband side in terms of his financial affidavits, 5 or 6 of them, his tax returns. This judge was faced with a very difficult task of trying to figure out the number of the husband's income. I don't know why the judge chose the $23,295 per month. Judge Black, you came up with a possible scenario.
Well, it's pretty easy to come up with, I think. I think if you take the $280,000 gross figure that he's got in the judgment and divide it by 12, that's what you get.
Right.
I see what he did. I just don't see how he can do that legally.
And it may be exactly why he did that. I don't know. But to me, based upon the fact that the husband, the judge found, he lacked complete credibility as to his business expenses. He cooked the books, grossly inflated his expenses. I think the trial judge just did the best that he could. Granted, I agree that, the statutory deductions, taxes, health insurance, those things, it's not clear that those were in fact deducted. But the total amount, according to the husband, on his financial affidavit as to those expenses, those statutory deductions, was about $3,000 or so. That combined with, his business expenses, which there was a lot of testimony, and it came from the husband's side about his business expenses that showed, and I think in my brief, I think the number I came up with, which I will concede, at least $408 per month in business expenses were established by the evidence. But if you take the $3,000 in statutory deductions and the $408 that I concede are reasonable and necessary business expenses, we wind up with the husband still having $19,628 net monthly income, which he clearly has the ability to pay the $6,798 in alimony that was awarded. You guys can remand this back. I don't know if on remand the judge, if it's the same judge or a new judge, will ever be able to figure out what this guy's income is, gross or net, because it's a moving target. And I think it would be a waste of the court's time to do that, because we'll wind up with a different number, and we may all be back here again arguing about what his income is. And even using the husband's own numbers.
The test isn't what you concede to. The test is what does the record show. And there's nothing in the record to suggest that the business expenses are unreasonable.
What the record shows, and if you'd like, I can go through each one of them. I did it in my brief, and I honestly, reading it last night, it was really boring to read, but I will do it.
You don't have to do that.
If you go through it.
The number, you concede that the number the court came up with cannot possibly be right.
I would concede that there are no statutory deductions that appear to be deducted, because the final judgment does not detail what was deducted and what was not deducted. We've just got the judge saying, this is the number. And none of us really know where that number came from.
Well, isn't that the risk the trial court takes if you write a judgment in an effort to evade appellate review, that you get to do it again? Because if you don't put the findings and tell us of the reasoning, and if he has competent substantial evidence, we'll get affirmed. But if you leave it there and you leave it blank and tell us, try theoretically to perform your function of appellate review, but I'm not going to tell you what I did, isn't that the risk the trial court runs?
It is a risk, but I think with the evidence as to the business expenses, the husband had, I think it was $5,000 per month total business expenses, and there was competent substantial evidence presented by the husband which refuted that he actually incurred those expenses. It was, the testimony of Mr. Mannix went, line item by line item and refuted most of what the husband said were the business expenses. And that's where I came up with the $408, which, like I said, I detailed in my brief. So, I mean, the husband's own evidence refuted the amount that, the husband said was his net income. The only thing I'm willing to concede, and just to be clear, was it's not clear that the statutory deductions were in fact deducted. I can't tell. And it doesn't look, based on the child support guidelines, when you look at it, it doesn't look like they were. And they're about $3,000. You could remand it back and say, $3,000, adjust on the child support guidelines. But even with the $3,000, he still had the ability to pay the alimony that was awarded. And on the deduction, the taxability issue, the trial judge, the statute requires the trial judge to consider taxability. This judge considered taxability. It's evident from the final judgment. He decided we're not going to do that. And Judge Blagg, you may be absolutely correct about, that it may be of a tax benefit, but there's nothing in the record that would support that. And again, Judge Kazam, you pointed this out to me. The standard here is abuse of discretion, and I would submit that no abuse of discretion has been shown by what the trial judge did here. I mean, you may not like the reason that the trial judge gave, but it's not wrong that he decided not to do it. And there's case law to support that you don't have to tax impact, even though I would completely agree with you. It's the usual way things are done. The usual way things are done doesn't necessarily mean what the trial judge did here was wrong. If I didn't say, I'd like maybe a minute to rebut Ms. Vedder. Thank you.
Well, just briefly, first of all, Mr. Moore's financial affidavit did not list $23,000 something a month as gross income. It listed it as the gross income is $17,790.01 gross after business expenses had been removed, but before all of the statutory deductions. That was the amount that was listed. Once again, appellee is trying to argue that Mr. Mannix, the colleague of Mr. Moore's at Excalibur, is saying that he pays for all of Mr. Moore's business expenses. The court, I know, has read the pertinent parts of the transcript, and the court knows that that is simply not the case. That is not what he said at all. And the interesting thing about it is that this argument that, well, all he could do is turn in receipts and get paid, they will be paid by Excalibur. Well, yes, they might be, but guess what? It comes right off the top of his commissions. So either way, they're going to get deducted. It's either going to get deducted off the top of his commissions, or he's going to deduct them minus 1099, which is the appropriate way to do it. So the argument that has been used by appellee and by the trial counsel for the wife just doesn't wash. As far as the cross appeal is concerned, I think the court is correct in saying that this was an abuse of discretion. First of all, as far as the life insurance, they didn't ask for it. There was no testimony during the hearing that she wanted it. There was no request during the closing argument. And worse than that, and that would in itself would have made an error if the court had awarded any life insurance, but that requires special circumstances. There was no attempt to establish any special circumstances requiring life insurance. There was no evidence of his insurability, and he has a medical condition. That's critical. And then, of course, his ability to pay insurance. None of that was in evidence. So obviously, there's no abuse of discretion to deny the insurance. And there was only a $10,000 policy that was provided by Excalibur. As far as the guideline support, again, the court made a finding that there was conflicting evidence as to how much, whether Daniel needed $1,000 a month in after-school care, parenting care. So he chose to disregard the $1,000. As far as any other expenses on the part of Daniel, there was no testimony as to any specific expenses. So again, the wife had not met her burden in proving the need or the cost of those expenses, and the court was right in not going beyond support guidelines. Thank you very much.
Sorry to come back. The life insurance, the special circumstances obviously was Daniel. He was already insured, so insurance was available. He clearly had the ability to pay $23,000 a month. The wise financial affidavit elaborated the expenses as to Daniel that were outside the ordinary. Thank you very much.
Thank you both.
Thank you.
It's a shame you can't save your extra time for your next oral argument. There's no rollover.
We can't tack that on.
I guess you're welcome to try.
The next